election petition was basically a challenge against the declaration of the results and not, emphasis, not the validity of the election. It was the declaration of the results that the petitioner sought to challenge. But the courts held that the declaration of the results is done in consonance with the data provided by first respondent. That is the total number of votes cast, the total number of valid votes cast, and the percentage of the total number of valid votes cast, and not the total number of votes cast. I want to stress the difference. It's a percentage of the total number of valid votes cast, and not the total number of votes cast. And by the data provided, the justices were left in no dispute that second respondent, His Excellency Nana Addo Dankwa Akufo-Addo, President of the Republic of Ghana, and still the Commander-in-Chief of the Ghana Armed Forces, had crossed the threshold of more than 50% plus of the total number of valid votes cast. In consonance or in tandem with Article 63(3) of the Constitution 1992. The court had a word or two to say about the testimony of the witnesses for the petitioner. And you heard the court rightly say that the petitioner was under no obligation to offer evidence himself by the presentation of a witness statement and mounting the witness box to testify. So was it that there was no compelling reason why first respondent and second respondent should have been made by all means to also adduce evidence in the trial. So there is parity of justice. Your Lordship said that the evidence of PW1, PW2, and PW3, that is Dr. Michael Pesa-White, and Mr. Johnson Asiedunkit, and Mr. Robert Joseph Metanunu. And I'll borrow the language of the court. It's not my language. The justices said their evidence was fanciful, and the least said about the evidence of these two persons, the better. That is not my language. That is the language of the Chief Justice of the Republic and of the court. Why did they say so? From the evidence adduced at the trial, their own evidence, they have certified 13 of the 16 regional collation results, and when they realized that the other 3 results were not favorable to their cause, they abandoned ship and left the National Collation Room of First Respondent, what hitherto was called the Strong Room. Your Lordship said they abdicated their duty and their evidence that they were tricked by First Respondent's chairperson to vacate the room before the declaration of results was unworthy of consideration, and that they should blame themselves for abandoning posts and not shift blame onto the doorstep of the First Respondent's chairperson. This is the language of the court. In fact, the court also said that they have 2 additional agents, so that even if they left, the 2 of them left, the 2 additional agents could have done what they should have done as agents in the collation room. PW2 2 and plea W3 were under no obligation to leave the room, and the fact that they decided to leave they cannot complain of the declaration made in the error. Now, when it came to the star witness, Johnson Asiedu Nkecha, this is what the court said. We did not come to court to challenge the figures declared by first respondent, but that the figures declared contain errors, and in affecting the errors, the EC chairperson unilaterally declared the results contrary to Article 23 and 296 of the Constitution 1992. The Lordships posed a rhetorical question that what was the effect of this? And the answer was forthright. The Lordship said the petitioner did not present any compelling evidence that there were breaches of discretion of Articles 23 and 296 of the Constitution 1992, and that errors by administrative tribunals are not matters for determination by the Supreme Court. That challenge lies squarely with the High Court. And that the discretionary power, if not exercised according to law, does not invalidate the valid votes cast at the election, and that those errors cannot amount to an invocation of the original jurisdiction of the Supreme Court. I will shortly, in the course of my delivery, tell you some significant portions of the evidence which were quoted extensively by the justices to found reasons for the judgment. Now, there were 5 issues that were settled between the parties for the consideration of the court. The first one was whether or not the petition disclosed any reasonable cause of action, and the others followed. It's whether or not the petitioner, the second respondent, obtained more than 50% plus of the total number of valid votes cast at the election, and whether or not the alleged vote padding and errors substantially affected or materially affected the outcome of the election. There were other ancillary reliefs of a breach of Article 23 and 296 of the Constitution 1992, a mandatory injunction placed on the EC, and also an injunction to restrain the President from holding himself out as President of the Republic, and for that matter, carrying out his duties as the first gentleman of the land. It is instructive to state that the courts decisively determined these issues in favor of the respondents. Indeed, to do fidelity to the Supreme Court and the truth, we cannot run away from the fact that the Supreme Court did not agree with the first and second respondents on the first issue, that the petition did not disclose any reasonable cause of action. But they were quick to also say that the petition will not be determined alone on that issue, and that the totality of the evidence will be called into play to ascertain whether or not the claims by the petitioner that none of them, that is the petitioner and second respondent, crossed more than the 50% threshold as mandated by Article 63.3 of the 1992 Constitution. Now, this is what the justices of the Supreme Court said to clarify and put to rest this thorny issue. Now, the actual total number of valid votes cast at the election, which was admitted in paragraph 12 of the petition and confirmed by the star witness Asiedun Ketia, was 30,121,111 votes. Now, the court also said that a party is always bound by its pleadings, and the only way the party can free itself from its pleadings is by way of an amendment. The admitted position of the petition, which was unraveled under cross-examination by second respondent's counsel, the Venerable Anthony Akoto Ampao. I bet most of you didn't know the first name. As the Venerable Anthony Akoto Ampao. When the video clip was played in court. Now, second respondent garnered 6,730,413 votes. Petitioner garnered 6,214,899 votes. And the percentage of the valid votes, of the votes obtained against the total number of valid votes cast, came to 51.295% for second respondent, His Excellency Nana Addo Dankwa Akufo-Addo, and 47.366% for the petitioner John Dramani Mahama, meaning that second respondent had crossed more than the 50% plus of the total number of valid votes cast at the election, which was in contradistinction to what the petitioner had been saying all along. In the first place, before this petition was filed, the petitioner was bold to say that he had won the election, and the Deputy General Secretary of the NDC gave the petitioner a percentage of 50.15%. You heard it when the video clip was played. Indeed, Sami Jemfi, the communication officer of the NDC, hailed John Dramani Mahama as the president-elect. This position taken by the Supreme Court was not done in a vacuum. It was elicited from cross-examination of their star witness, PW1, by the Venerable Akoto Ampao. And you heard the rendition, which was loosely given by the Supreme Court. Now, the Supreme Court also considered the Techiman South constituency presidential election results, which became a thorny issue in the declaration. It was the first respondent chairperson alluded to the fact that even if the Techiman South, what's happening? Even if the Petition South election results, presidential results, were added to the results at the time of the declaration, the second respondent still won the presidential election by more than 50% of the valid votes cast at the election. Now, the declaration of the results was tendered in evidence by the petitioner as Exhibit A. And Exhibit A clearly showed that the votes at the Petition South constituency, and that without the Petition South constituency election results, second respondent crossed the threshold and obtained more than 50% plus of the total number of white votes cast. The addition of the Petition South constituency results was played out in the manner following. The total number of registered voters in that constituency was 128,018, but 99,436 valid votes were cast at the election. And out of that number, the petitioner John Dramani Mahama received 52,034 of the valid vote cast, which put his total number of valid vote cast at 6,266,923 votes, which represented 46.379%. Second respondent, Nanado Dankwa Akufo-Addo, received 46,379 votes, moving his total number of valid votes cast to 6,776,792, which gave him a percentage of 51.295%, meaning that second respondent had crossed the threshold of 50% plus one. The Supreme Court justices also held that in fact and indeed the results of the Petition South constituency presidential election was well known to the petitioner before the petition was filed. And for that matter, even an exclusion or inclusion of the Petition South presidential results wouldn't have made any difference at all to the results as declared by the EC's chairperson. And now that even if the total valid votes, all the votes are added, Nanado Dankwa still received 6,730,413 total number of valid vote cast, and that of a percentage of 30,249,129 votes would have given him 50.798% votes cast. As to the alleged vote padding and the wrong aggregation of votes, the Supreme Court dismissed those allegations with consummate ease. Indeed, if you added the votes that they themselves said were padded, in one instance it's 6,622, another instance is 5,562, and then when it mattered most, they initially started with 32 constituencies and it dwindled. They started with 32 constituencies, and it dwindled to 26 constituencies, and the vote pardon came to 4,693. Now the courts were clear that these votes, even if taken out of second respondents' votes garnered, did not materially or substantially affect the validity of the election. The Supreme Court also said that the alleged vote pardon was not supported by any credible evidence, and you can't rely on infractions that affected votes at polling stations when the votes are validly cast. Administrative errors or mistakes by electoral officers can never and will never change the sovereign will of the voters who cast their votes at the election. And your lordships quoted a passage from Lord Denning to support that position of the law. Ladies and gentlemen of the press, in short and in brief, this is the thrust of the judgment of the highest court of our land. And your lordships posited that one cannot ignore the substantive truth of an election and resort to innocuous errors committed by first respondent chairperson in the declaration of the results, and on that position call for a rerun of the election. Your lordships also stated that the petitioner was not able to bring one single piece of evidence to show that allegation that none of them, that is the petitioner and the second respondent, crossed the 50 plus of the total number of valid vote casts to warrant a rerun of the election. The Lord Justices of the Supreme Court have spoken. We entreat all Ghanaians to abide by the decision of our highest court of the land. We thank our good friends on the other side for their bravery in mounting this petition. Albeit we all found that the petition indeed contained nothing but factual errors and inaccuracies. Those were in the words of the court, not mine. Litigation must always come to an end. I don't believe that this is the end of the 2020 election petition. I'm fixated with 2013, so spare me. Ladies and gentlemen of the press, if there are any questions, we are prepared. I'll do that. If they don't, Elvis. If there are any questions, we will take them. The mic put up my way. That's why I said they could ask questions. They don't I think you have no questions. Do you have any questions? Don't worry. We'll do that. That being the case, can someone fetch Sheshe? Sheshe is standing there. That being the case, on my own behalf, on behalf of the National Chairman of the NPP, the General Secretary, the Campaign Manager, the National Youth Organizer, the National Organizer, because the National Women's Organizer, she just left us, the Nasara Coordinator, the Campaign Manager, and our star witness, the redoubtable and irredoubtable Peter Mark Menu. We want to thank all of you, ladies and gentlemen of the press. Of course, our Director of Election will do that. Our Director of Election and adjunct lawyer, Ivan Simako, and I almost fell into trouble. The master tactician, the technical wizard, the little boy computer, Joe Anochi. We thank you all for the enormous assistance you have given for bringing this petition to the doorstep of the people of Ghana, and for the belief you people have had in the process. Yes, our justices are human beings, they are fallible, but when they decide on a matter, that obviously should bring that matter to an end. There are other means of challenging their verdict, that is if the petitioner is wont to do so. But we pray that Ghanaians should accept the rendition of the Supreme Court in the supreme interest of justice, so that governance of the country can continue in these challenging times of the economic rostrum of the world. We have COVID to confront with. His Excellency the President should be given all the support, together with his ministers and parliamentarians, political appointees and government functionaries, to manage and run the machinery of state. Now, I would say something which rhymes with what the Supreme Court said. So I'm borrowing their language to say just something small, the Ghanaian public. The Supreme Court said we should not ignore the substantive truth of any election. So, ladies and gentlemen of the media and our fellow countrymen and women, the verdict of our Lord Justices of the Supreme Court has been handed down in cold print by an unanimous decision of 7 justices of the Supreme Court. And I want to say, for the purposes of emphasis, that no matter sartorial elegance or glamorously attired and adorned, a provocative misrepresentation of the correct legal position is, the naked truth, and I repeat, the naked truth shall always prevail, as loudly pronounced by the highest court of the land. Need I say, the battle is still the Lord's. Thank you.
Amen. Please don't go, don't go. Mokwa.
Please, let's do the tree.
Ebedam wase me bonu tiawa. Asama me penny lawyer Frank Viscan in say and this for us say adaje e court. Assembly nyina and abana wie ye. Wo hwe NDC asama no mo de nam nyina o say aba ye to ye no na nado danko akufuado enya ohamu nchidemu aduonum ene akire. Ene Supreme Court mpanifo de omano asema tudwa. Omo say nana ado danko akufuado ye namra kwanso Ghana fro eto aba edmano. Ene asem no tia wo nyina nie. Ne tosu menu hwe nsem ni nyina nso a medika ka omampani dada Mahama wasaya daje nanso court de wo de wasem ba court ebetie wasem nya ye besre ene akwakoye asedanwum ena wo ya no ene court batan ede nanu asem atudwa nana adodankwa akufuado His Excellency ono ena ye omampani a yeto abayi no ono ena ye first gentleman of the land ono ena otoa na dwumaso mesre se nyina yede odo ne nkabom ebeta achi enyuntofo ne se asempapa bi amate oye saa nyumi nanado danko kufuado ahye na kumuma yeda obi bia ase nyame nchiramo eye lawyer Frank Davis ebodi lawyer Koku Esifika ho lawyer Dapa Adoka ho lawyer Menka Premo Shela Menka Premo lawyer Victoria Bath lawyer Akutampa Nemu Maboni Dindada lawyer Dr. Elisto Usudapa lawyer Ochri Ejekun communications team ayenemu edi ejumai lawyer Nanajua Adubia Asante and minister in charge of information minister Kojo Oponkroma yaw boabenya samwa lawyer enso kan ye ho miami mu na menuaba Hajia Fatimatu Abubakar ya introduce star witness empanifo akenya bedam nyamase media you have been phenomenal nyame nhira mo mata ya chi ama yedi dwumadie senia ese nyame nhira obibia.
All right, and that was the final press conference, this election petition hearing. Of course, the decision arrived at by the court was that the petition brought before it did not have any merit, and therefore the petition was dismissed. Right after that, as we have become used to, the parties involved, especially the petitioner and the second respondent's spokespersons, normally address the media. However, when petitioners' spokespersons came to the podium to address the media today, the point was very simple, that the petitioner himself, in this case former President John Dramani Mahama, will be addressing the media at exactly 5 p.m. today, and therefore all the reactions that the world needs to know from the petitioner's angle will be delivered at 5, and we surely will be there to bring you all the details and more. And then the court has dismissed that petition. Of course, the petition brought before us, this will have been the 18th day, exactly 18th day of the sitting. 12 of those days were to look at the substantive matters. 5 of those days looked at the pre-trial cases, and today being the 18th day, the court arrived at a decision. Of course, the petition was for the Supreme Court to annul the results as were declared on the 9th of December by the chairperson of the Electoral Commission and declare a rerun of the election between former President John Mahama and President Akufo-Addo. Of course, that has not happened. In between, where there were calls and applications for interrogatories, applications by the petitioner for the first respondent to allow him to inspect some documents that were in the possession of the first respondent. That also was dismissed. Then the cross-examination, indeed, the cross-examination of Mr. Johnson Esedun Ketia, the petitioner's witness number 1 came for mention several times in the final judgment today, and the indication was that most of the answers that he gave indicated that whether or not they were vote pardon or whether or not the petitioner, the second respondent made some errors, that those errors did not essentially affect the outcome of the final results of election 2020. That has been it. And I would like to say a very big thank you to all of you who have kept faith with us here at GBC, and then of course to the entire crew, the directors, the cameramen, and all those who were tirelessly behind the scenes, all our studio guests and experts who were giving us the analysis from the studio, my co-presenters Maurice Ogbete and George Sapo, and everyone else who played a part in this, the head of news GBC, Akushikakwe, and everyone else who made this a possibility. We say thank you to you. Keep faith with GBC always, as we will continue to bring you at this highest level all the undiluted, authentic information. GBC, the authentic and trusted voice of Ghana. This has been our coverage of Election Petition 2020. Thank you very much for being a part of it. We'll see you again some other time. Bye-bye.
And thanks to Abdul Haim Mumin together with the entire team at the Supreme Court there, and we're back here to the studios, and I'm sure by now you all know the 7-member panel of the Supreme Court has unanimously dismissed the 2020 presidential election petition. In summary, it said that the case has no merit. There have been other sides and stuff within the ruling itself, but in summary, that's exactly what the court said. Maurice.
And so it means that President Nana Addo Dankwa Akufo-Addo will remain the president of the Republic of Ghana. According to the Supreme Court, he gained more than 50% of the valid vote cast in the 2020 presidential elections, and so accordingly there will be no grounds to call for a rerun between him and His Excellency John Dramani Mahama, the petitioner. We are still here in the studio with our guest lawyer Kuku Ajiman Budu. He's a lawyer and the head of law centers at Gimpa. It looks like a lot has been said already. I mean, the ruling has been delivered and everybody knows exactly what it is, but you just want to take us through briefly, yeah. I mean, from your point, what the justices have said.
Okay, all right. So essentially, we've heard everything. The Honorable Chief Justice has read the judgment of the court. It took about 2 hours to deliver the full judgment, and we've seen that the counsel or representatives of the second respondent have also sought to summarize what the court said, and the petitioner has suggested that they'll be addressing, or he'll be addressing the public at 5 p.m. tonight. But generally, if you listen to the judgment as read by the court, you can see that it was structured in a way that follows the trajectory of the case, how the case has progressed so far. So they started by recounting what led to the petition in the first place and the processes that ensued, all the way to how the court decided then to set out the issues, the triable issues that they felt they had to determine in order to determine the petition. And then they came to talk about the trial itself and the standard of proof, the burden of proof, burden of persuasion, burden of producing evidence, trying to see which party bore those burdens at what particular point in time. So they talk a little bit about it before they come to deal with the 5 issues that they set out. And the first issue was that which we were discussing earlier on, which had to do with a preliminary objection. The court made sure to recognize that fact that both parties had raised preliminary objections, but the court in its wisdom had decided to deal with it when it was dealing with its final judgment. And that preliminary objection, which made it to be the first issue, was whether or not the petition disclosed a reasonable course of action. And after examining the authorities and examining the arguments that all parties made, the court was of the view that the strength of a case, the petitioner's case, ought to be determined on the basis of the case that he made, and on the little that they had shown at that particular point in time. There were issues that ought to be resolved that affects the conduct of the election. So to that extent, indeed, there were or the allegations that were made related to the integrity of the election, and if it was proved, or if the petitioner was able to prove those allegations, there will be valid grounds to challenge the validity of the election. So to that effect, the court was of the view that indeed the petition disclosed a reasonable course of action. So that was the first determination in terms of the first issue.
If the court had gone the other way with that determination, obviously there would be no need to even go to the second to the fourth issue.
That would have ended everything then, because if you don't have any course of action, there's no point in proceeding anyway. Then the court then went on to the second issue that had to do with the data contained in the declaration by the first respondent, and the idea that no candidate on the basis of that declaration crossed the more than 50% threshold. And once again, the court went through the evidence that had been adduced at the trial and came to the conclusion that on the basis of the evidence adduced by PW1, that's the first petitioner's witness, that's Johnson Asiedu Nketia, he had admitted that indeed the valid votes cast, the total valid votes cast for the election was 13,121,111. And so the error that was made, and the court made it clear that indeed there was an error that was made by the Electoral Commission. It can be deduced from the pleadings of the Electoral Commission itself that indeed they made an error in the declaration that was made on the 9th. And that in reading out the total valid votes cast, she read out the total votes cast. And we know that the prescription under Article 63 is that the winner of the election must have gotten more than 50% of the total valid votes cast, not the total votes cast. And so to use the correct figure of 13,121,111, and the fact that the Electoral Commission had gone ahead to correct or made those corrections in the subsequent press release and all that, was clear that if you base it on that, if you base the declaration on the basis of the correct figures, that indeed a candidate crossed the more than 50% of the total valid votes cast.
Maybe I'll ask you the question I asked in the morning. That press release, which according to the petitioners was unsigned, was it under the hand of the Electoral Commissioner, and does it amount to a declaration of the results? So
the press release was issued by the Electoral Commission. It wasn't actually signed by the Electoral Commissioner, as we are aware of. It was issued by the Electoral Commission. But what we were talking about earlier on, you remember I made mention of a Supreme Court case. That was the case of Metonunu and the Electoral Commission. It was a 2007-2008 Supreme Court of Ghana Law Reports case, where the Supreme Court held that the 21 days within which the petition must be submitted starts from the date the results were gazetted by the Electoral Commission, and not the date the provisional results were announced. Which means that the provisional results are what the Electoral Commission chairperson announces.
Okay. But the main result is what is gazetted.
What is gazetted? That's what the presidential election, presidential elect instrument. That's CI 135 that was passed by the Electoral Commission. There's also the Republican High Court Fast Track Division Ex Parte Electoral Commission. That's a 2005-2006 case, where the Supreme Court also held that a mere fact that an action can or has been commenced in relation to an election and called for interpretation of some provisions of the Constitution did not necessarily make it an action challenging the validity of the election of a president, and that it shall be commenced by a petition, that action that you want to challenge, in the prescribed form within 21 days from the date of the declaration of the results in the Gazette.
Okay.
So that is what the Supreme Court has said in past cases.
All right. So the Supreme Court actually described the issue 2 or issue B as a determining issue. I mean, so it has a bearing on the subsequent release or the issues that...
No, actually it was the relief B.
The relief
B of the petitioner's petition, amended petition, is what the Supreme Court said was the fulcrum around which everything revolved, and that was the relief to the effect that we wanted a declaration that based on the data contained in the declaration made by the Electoral Commission, no candidate satisfied the requirement under Article 63(3) of the Constitution to be declared president-elect. Yes.
Okay. All right. The only option left for the petitioners will be for a review, which is allowed. And I think we touched on that earlier. And we were told that the petitioner, who also led the NDC into the 2016 elections, will be actually the 2020 elections will announce or have a press conference this evening at 5. We'll get to exactly what he's going to say. On that note, I think we'll leave everything here now, Maurice.
Maybe we just want to go through the issues.
The few other, okay, let's just finish up.
Yes, so the next one was the issue of Techiman South.
Yes.
Remember, there was the argument that with or without Techiman South, would anyone have crossed that threshold? And the Supreme Court once again goes back to the total valid votes cast, because it's been established that indeed the total valid votes cast was 13,121,111. If you use that number in calculating what the percentage was in terms of what the two candidates got, then indeed one candidate, even with
the Techiman
South results of 128,018,
which cannot be possible.
Yes, because at the time, exactly, because at the time of the petition, and the court said this as well, that the parties knew what each one got, that the petitioner, I believe, got over 52,000 and the second respondent got over 46,000. But that notwithstanding, even if you gave all 128,018 votes in Techiman South to the petitioner, and you use the correct total valid votes cast of 13,121,111, still the second respondent crosses that threshold. It is when you use the wrong, erroneous figure, which the court will not use anyway, because it was clear that the Electoral Commission chairperson had corrected that figure, or attempted to correct that figure the very next day, which the PW1 actually admits that is the total valid votes cast. And then the next issue was also had to do with whether there had been a violation of Article 63(3) of the Constitution by virtue of the declaration, and the court arrived at the same conclusion that there wasn't any such violation, because of the fact that if you look at the total valid votes cast and you look at the votes and the fact that the petitioner, even though he was alleging some errors and all that, or the thrust of the case being based on the errors made, those errors could not void the declaration. Assuming those errors existed, they could not even void the declaration as announced by the chairperson of the Electoral Commission. To hold otherwise would mean that errors that do not impact the results may be deemed to invalidate an election, which is a situation that we should not get to. At least that's what the court was saying. And then the final issue had to do with the alleged vote padding and other errors that existed. And once again, on the basis of the evidence adduced, the court was of the opinion that first and foremost, the numbers involved were insignificant. So assuming that even if it was established that the 5,662, which ended up being 4,693 thereabouts, even if it was established that there were vote pardons and it was proved it was insignificant to detract from the results, and that in any case there was no material evidence that the petitioner had introduced to prove that particular allegation. So on that basis, that particular issue was determined. So the petition failed and was dismissed as having no merit.
So even though the vote padding did not affect the results, doesn't it affect the credibility of an election? So that, I mean, even when it doesn't affect results, we shouldn't entertain vote padding in elections.
Yes, of course, and that's what the court essentially said, that allegations of vote padding were serious, because if they are proved, it will affect the integrity of the results. But on the basis of the evidence before it, the court is saying that they had not been proved, and that material evidence had not been introduced by the petitioner to even establish those figures that allege vote padding, and that any infraction must affect the votes that have been actually cast. And the conclusion was that the petitioner did not show how the alleged errors even affected the results, because you remember that the petitioner introduced samples that are about, was it 26 constituencies or something, showing alleged vote pattern. So it was just samples that they introduced, not necessarily the entire picture of the election as a whole. And that's what the court was saying, that the PW1 was even being evasive when some of the questions were asked in terms of if you subtract or the alleged figure involved in the vote pattern from that of the second respondent still gets enough to cross that threshold. And PW1 was evasive in some way, trying to avoid the question, saying you can't subtract samples from whole figures and things of that sort. So the court basically was on the opinion that on the basis of the evidence in relation to that particular allegation of vote pattern, first and foremost, it had not been proved. If it was proved, it would have to even have a material effect on the outcome of the results, but in any case was not proved by the petitioner.
All right, I know you don't like to answer questions like this, but did you think that the petitioner over-relied on the 9th declaration, avoiding the subsequent corrections that were made?
That's basically what the court arrives at, that the thrust of the case seems to be, and right from the beginning you heard, and once again, once we get the actual judgment, we'll be able to do an in-depth analysis of the judgment. But from the little that we heard, what the court was saying was that the petitioner seems to have overly relied on that declaration based on the erroneous valid votes cast that the Electoral Commission chairperson put out, which she had even, or the commission had gone ahead to correct the very next day. And so the court itself said that it seems to have overly relied, the petitioner had overly relied on that, and that seems to have been the make or break one way or the other, because it's, in one sense, yes, the petitioner states, and even the respondents admit that the total valid votes cast that the Electoral Commission chairperson announced when given the provisional results on the 9th was wrong. But instead of mentioning the total valid votes cast, she mentioned the total vote cast. And we know that we can't declare a president on the basis of the total votes cast, and that if you want to challenge the validity of the election, then the onus will now be on you to show that on the basis of the total valid votes cast, that is the 13,121,111, that no candidate indeed obtained that more than 50% threshold, and that is what the court believes the petitioner was not able to establish in this particular instance.
Right, again, I know you're a lecturer, so you do some consultancy for that matter. Did you see maybe any lapses, in the petitioner's case that, if you got opportunity, you would like to maybe advise, or were there any lapses
I
in
don't
way
think
of,
I'm-
of strategy?
I don't think I'm qualified.
Witnesses and
I'm not qualified to advise
Sure,
people on the way and manner in which petitions. What I can say is that the petitioners obviously put up a case which they believed was strong enough, but it goes back to the point that in law, at the end of the day, it is what you're able to establish. And you need to be able to establish with evidence, with some form of evidence. And that is what I believe the court feels the petitioner has not been able to do. And it seems as though a lot was relied, the petitioner relied a lot on the evidence of their first witness, because it seems as though the second and third witnesses' evidence was not convincing enough to the court in terms of the.
But the court didn't touch on from 13. Did the court touch on from?
I mean, once again, we would have to read the entire judgment to be able to deduce exactly what they're saying. But I mean, if before you get to Form 13, which is the declaration, and I believe the court even talked about the fact that the various candidates or various representatives of the various candidates were at the collation center, the National Collation Center, which is referred to as the strong room, and that the petitioner had not been able to show that their absence from the strong room of their two representatives, and they had backups anyway, but the absence from the strong room, in their absence, something untoward had happened that affected the results. And I believe we heard somewhere that the court suggested they could have called any of the other representatives in that strong room to lead evidence to show that something untoward happened. And to the extent that they've not been able to establish that they are non-presence, if we may put it that way, did lead to some untoward things happening or some manipulations, then they had not been able to establish anything. So I think that deals with the issue of the Form 13 in that regard, because it's in the strong room that the Form 13 was signed by the representatives of the party.
All right, so finally, moving on. Now the verdict is out. We've got to know the judgment. Justice emanates from the people. How should the people actually handle everything that has gone on in the interest of the country, so that just as what the Judicial Service said earlier in the statement issued through its lawyer, a subsequent press conference by the two, which is the DG and the Judicial Service, so that we can have that understanding and not read certain meanings into what has happened?
I think just like how in 2013 the Supreme Court gave its decision, its judgment, and some persons, especially the petitioner then, was unhappy with the decision but accepted it.
The verdict.
There's no other option for the petitioner in this case. I mean, there is the option of applying for a review, which we must note is available to the petitioner. But at the end of the day, the decisions of, like you rightly pointed out, justice emanates from the people, and it is administered on our behalf by the Supreme Court or the judiciary generally. And so we need to accept decisions of the Supreme Court once they have been given, because litigation must come to an end at some point in time or the other. What we can do as a people, what we can do as a nation, is to figure out a way of harmonizing and streamlining our electoral processes. Because like you heard the Honorable Chief Justice mention, he quoted from the 2012 election petition, where one of the justices clearly pointed out that elections are conducted by fallible human beings. They are bound to make mistakes. But those mistakes should not be mistakes that will affect the credibility of the results. It should not affect the sovereign will of the people. And I believe that one thing that we should do, or one thing that we can think about doing, is revising our election calendar. You know, there's nowhere in the Constitution that says
we should vote on
the 7th of December. It's just by practice and to reduce cost and all that, the Electoral Commission decides to fix that date so it coincides with the last day they can hold an election for parliamentary elections. Actually, we have between September and December to conduct a presidential election, because the constitution says when there's a sitting president, an election must be conducted not earlier than 4 months or later than 1 month before the expiry of the term of the president. So it will be appropriate and better to hold our elections prior to December 7th. Probably if we even hold it a month earlier, that's the presidential election. Because for the parliamentary election, it seems that it has to be conducted a month before the exit office or parliament is no longer.
But that's when someone will also argue that if we should hold the presidential election earlier, it will have a way of influencing the outcome of the parliament.
In 1992, the presidential election that was held in November, and then there was subsequently the parliamentary election that was held in December that was boycotted by the MPP and all that. I mean, those arguments exist.
Yeah.
It's a legitimate argument. But if we're building a democracy and we want to appreciate the sovereign will of the people, shouldn't matter that we've held a presidential election on this day. So if we go and hold it parliamentary election subsequently, the results of the presidential election will influence. Doesn't matter. I mean, are we taking away the sovereign will of the people by suggesting that simply because an election is held earlier, the results will impact that of the other? It's something that we need to be thinking about, because there are jurisdictions in which there are elections almost every 2 years. In the United States, for instance, they have midterm elections. I'm not by any seconds comparing our democracy to the United States. So I'm just saying that there are some democracies that the term of the president does not necessarily is not necessarily in line with the term of the legislature, so that at every point in time, for instance, every 2 years, there is an election that is held where a certain percentage of seats are up for election. That's something that we may also want to think about. But the point that I was making was, if we are able to hold a presidential election earlier, say November, we would have enough time to resolve whatever disputes may arise prior to the handing over or the swearing-in ceremony, so that election petitions, for instance, may be determined within that period, so that we do not have this protracted period where we still have to go ahead and swear in the president anyway, because we can't have, for want of a better word, a vacuum or a presidentless country. That's not the word, but and all that. But if we are able to deal with those matters within that period, it will help grow our democracy. It would help ensure that before we get to 7th January, we've dealt with all issues that are at stake. The only thing is the legitimate question you raised. Then how does it impact on Parliament, the parliamentary elections? Or the fact that a candidate who has won the presidential election now be campaigning and saying, vote for my people so that I have a mandate to be able to rule the country. But we should get to the point where we appreciate that it is possible that one arm of government, like the legislature, may be controlled by a different political party, which may be inherently good for the development of our democracy, because Parliament will play the role that they are supposed to play as a check on the executive. But obviously these are things that we need to talk about and discuss and fashion a way forward for the development of our country and our democracy.
So as we wrap up, what would be that one thing that you like our viewers to take away from this election petition? What is that one lesson that you like them to learn from this petition?
Many lessons. So if you want to reduce it to
so
one, so one thing that I would like viewers to take away from this petition is that we need to respect the processes of the law. Especially, we need to understand that when allegations are made, they need to be substantiated. We need to know that when you're going to a court of law, it is not about things that people say on the streets or things that people say without any evidence. I mean, one key thing that I would like to say especially is that we should be able to at all times distinguish between what has been referred to as political talk and has more or less been accepted by all parties, which I have a fundamental problem with, because you can't say something is political talk, so let's not hold you accountable for that. But we need to distinguish between that and what the law says, so that when we are going to court, it is not political talk that you're going to establish in court. You're going to establish facts through evidence, so that on the preponderance of the evidence or on the balance of the probabilities, the court will believe what you are saying over what Morris is saying. That is what people need to understand. Then we also need to let people understand that let's stop politicizing everything in this country, because it seems as though everything is politicized to the point that there seems to be no objectivity on any issue. On almost every, and just going through this petition and scanning through social media, the level of abuse, the way and manner in which people talk, is just something that we need to be able to move away from. Let's debate our ideas dispassionately. Let's talk about facts. Let's buttress our arguments with some solid basis. But let's not go down the route of insulting simply because someone disagrees with you. Everybody may have their their political views or their own ideological beliefs and all that. But at the end of the day, we should appreciate the fact that Ghana belongs to all of us. We are all one way or the other on this Ghana ship, and we should play our part in contributing to the development of the country. If it means passionately disagreeing with someone, let's disagree with the people, devoid of insult, devoid of political polarization and those kinds of things. That's something that I hope people will be able to take up and help in our development as we go along.
All right, look, we'll leave it here. Before we go, this all this Supreme Court thing, I did one research. At least you're a lawyer, you're a law lecturer. Morris, there's a case, and Tufo versus the Attorney General, somewhere in the late 70s or the 80s thereabouts. And Tufo then a lecturer at the Kwame Nkrumah University of Science and Technology. It's got to do with the Chief Justice, then Justice, I think Justice Apalu. Yes, and Tufo had two lawyers that represented him, and there were two lawyers also for the state. The two lawyers for the state was Dr. Bill Randolph and A.L. Jabate. They represented the state. Now, two lawyers for Dr. Tufo was the current president, Nana Dankwa Akufo-Addo, and the lead counsel for the petitioner, Mr. Chachuti Kata. The two of them represented Dr. Tufo. And my research also, those who are around that time said that these two lawyers who represented Dr. Tufo, the current president and Mr. Chikata, wowed the judge. The judge really fell in love with their submission and how they handled the case in court. I'm just saying, fast forward 2021, both of them are against each other. I'm just saying. I'm just saying. So viewers, thank you very much for joining us. It's been great having you around, and thanks a lot for making us part of you, your morning and your afternoon, and all the days we had to sit for this entire hearing. We're so grateful that you stayed committed to us, and we hope and pray that we've also met your standard and your objective, that you kept watching us on Ghana Television and listening to us on Unique FM and all our regional radio stations. Thanks a lot, and we'll see you again when we see you again. My name is George Sapo.
George, we also want to thank Doc for his objective analysis. I mean, so far he's tried so hard to stay in the middle and not veer off. We want to say a very big thank you to Doc.
The doctor, Kwekwajimanudu.
You know, and also
he's a lawyer. He's a law lecturer and also the head of the Law Center's Gimba Faculty of Law. He's also the founder and executive director for the Justice Foundation. He's a big man.
Big one.
And he's been with us throughout.
Thanks a lot. Say thank you to our producers. They have been phenomenal. Ivan, Ponsa, and Pearl. I mean, they've been there to make sure that our job here in the studio is pretty much easier. We say a very big thank you to them, and the technical crew, the cameramen, the sound men, and the engineers behind the scenes who have made this possible. Thank you very much for your support. And
our correspondents also on the ground, both for television, radio, and the guys also at radio. Thanks a lot for all the support and the entire coverage. The thing about broadcasting is that you get to see few people, but there's a lot of people behind the scenes to ensure that you see what's happening on your television and you get to hear what's happening on your radio. Look, thank you very much, and wish you all the best. I'll think about maybe coming to Gimba to do law. All right, so we'll see you again. 2 o'clock will be time for News at 2 here on GVC News. Bye-bye.
Bye-bye.